Judgment in the matter of A1 Properties Limited against Tudor Studios RTM Company Limited.
This case is about the ability of leasehold tenants in a residential block of flats to take over control of the management of the block from their landlord. Parliament established a regime to allow for this in the Commonhold and Leasehold Reform Act 2002. Under that Act, tenants may acquire the right to take over the management of their block of flats through the formation of a right to manage company. Under Section 79(6) of the Act, the process by which the company acquires the right to manage the block requires the company to serve a claim notice on each person who is a landlord under a lease of the whole or any part of the premises. The 2002 Act does not contain a provision which states what is to happen if Section 79(6) is not fully complied with and a claim notice is served on some, but not all landlords. The dispute in this appeal concerns the right to manage Tudor Studios, a former factory in Leicester now converted into student accommodation and leased as flats with certain communal areas. The appellant, A1 Properties, holds the communal areas on 4 999-year leases from the freeholder. The appellant underlet the communal areas to a management company in 2009 at market rents. The tenant sought to acquire the right to manage Tudor Studios pursuant to the 2002 Act by setting up a right to manage company, which is the respondent to the appeal. The right to manage company served the claim notice required by Section 79(6) on the freeholder and the management company, but not on the appellant intermediate landlord. The management company served a counter notice stating that the respondent was not entitled to acquire the right to manage Tudor Studios because it had not complied with Section 79(6). The claim of the right to manage company was upheld by the first-tier tribunal. It followed a Court of Appeal decision in a case called Elim Court and ruled that the limited failure to comply with Section 79(6) which had occurred did not invalidate the operation of the statutory transfer process. The upper tribunal dismissed an appeal by the appellant, intermediate landlord of the communal areas, ruling that it was bound by the decision in Elim Court. The appellant has been allowed to appeal directly to the Supreme Court to test whether the decision in Elim Court is correct. That is the first issue in the appeal. The second issue in the appeal is whether, even if Elim Court is correct, nevertheless the failure to serve the claim notice in this case on the appellant had the effect of invalidating the right to manage acquisition process. This court unanimously dismisses the appeal. The judgment is given by Lord Briggs and Lord Sales. The court holds that the respondent's failure to serve a claim notice on the appellant did not invalidate the transfer of the right to manage. The court upholds the result in Elim Court, but departs from its reasoning. The appeal raises a general question about the approach to be adopted when a statute like the 2002 Act imposes procedural requirements for the operation of a statutory regime, but does not expressly say what will happen if those requirements are not fully complied with. The statute does not say what the effect will be where the regime is operated to a conclusion regardless of that procedural deficiency. This court explains that in such cases the proper approach is to consider the whole structure of the statutory regime within which the requirement arises and ask what consequence of non-compliance best fits the structure as a whole and best gives effect to the presumed intention of Parliament of what the consequence of that particular procedural breach should be. The focus is on the purpose served by the procedural requirement and on whether any prejudice might be caused or whether any injustice might arise if the validity of the statutory process is affirmed, notwithstanding the breach of that requirement. The question in this case is whether the failure of the right to manage company to serve a claim notice on one out of a range of landlords had the effect of invalidating the whole transfer procedure, so that the determination of the first-tier tribunal that the transfer of the right to manage was valid should be set aside. Applying the proper general approach in relation to Section 79(6) of the 2002 Act, the key issue is whether a relevant party has been deprived of a significant opportunity to have their opposition to the making of an order for the transfer of the right to manage considered, having regard to, first, the substantive force of the objections they could have raised, and secondly, to whether, despite the procedural omission, they in fact had the opportunity to have their objections considered. The focus is on the position of the party directly affected by the procedural omission, not some other party who was affected by it but chose not to complain. This means that a failure to serve a claim notice renders the transfer of the right to manage voidable, which is to say that the transfer is valid rather than void from the outset, but it is liable to be set aside at the instance of the relevant landlord who was entitled to receive, but was not given, a claim notice. The transfer will cease to be voidable once the matter has been before the tribunal and it approves the transfer scheme after consideration and rejection of the possible objections to it on the substantive merits. And that is what happened in this case. In addition, although it didn't receive a claim notice at the outset, the appellant had in fact been joined to the proceedings in the first-tier tribunal and had therefore had the same opportunity of participation which it would have had if it had been given a claim notice in compliance with section 79.6. It suffered no detriment as a result of the procedural omission. In the circumstances of this case, therefore, the transfer of the right to manage to the tenants' company was found to be valid and effective. Also, applying this analysis with reference to the facts in Elim Court, this court holds that the result in that case was correct. In that case, the tribunal had approved the transfer scheme, and the landlord whose procedural rights had been affected had not sought to be joined in the proceedings to assert its rights. However, this court determines that the approach of the Court of Appeal in Elim Court was not correct and requires some modification. Their approach was to say that a failure to comply with the procedural rights of an intermediate landlord who had no power of management would not invalidate the transfer process. But this does not give full value to the usual presumption that Parliament intends that a person should not be deprived of property or contractual rights, as happens when a transfer of the right to manage takes place, without being afforded a fair opportunity to enter objections. The effect of this court's judgment is that the reasoning in Elim Court is adjusted and corrected for the future. The transfer of the right to manage in the present case is found to be valid, and therefore the appeal in this case is dismissed.